This is News 12 Law Call.
Hi there. Thanks so much for staying up. I'm Neil Gordon, host of LawCall Zoom edition. We hope to be back in the studio in the next several weeks, but so pleased to be joined by the two partners from the Hawk Law Group, the founder, Vic Hawk, and Reed Sanders. Hello, gentlemen.
How's it going?
How you doing, Neil? Good to see you again.
Fantastic. Good to see you as well. And of course, our topic is slips, trips, and falls. And I automatically am reminded of that yellow cone at the big box store and wet liquid. But of course, slips, trips, and falls are so much more than that.
That's right. They are. They can be anything from inadequate handicap ramp, stuff being left on the floor that should have been cleaned up, warnings that should have been put out. And then you can have construction types of falls that were caused by others. Reed is really our specialist on slips, trips, and falls.
Yeah, and Neil, like you said, most of that invokes in people's minds, a slip and a fall in a store. But it, like Vic just elaborated on, I mean, there's hundreds of different types of slips, trips, and falls, if to put it that way. But it's, it can be gas leaks. It can be anytime that you're hurt or injured in a home or store, it could potentially be a premise liability case.
Well, and that's the subject of our first email question, something going on in a home. Vic, this is from Matthew, who keeps several guns in a locked safe in his home. And he wanted to know if someone broke into the safe and caused an injury or death with one of his guns, would Matthew be liable?
Matthew, you would not be liable. If you have your gun safely locked away and a third party commits a crime by stealing it from you and then uses those guns, you're not going to be held responsible for that. I mean, I would think even if you have it just in your own closet and somebody breaks into your home or steals from you unknowingly, you're not going to be responsible for any injury that person caused.
And the only thing that I can think of that he may be, and we've had a case similar to this, Vic, where you invite children over or young adults over, and you don't have the guns locked away, and then somebody gets injured with that gun, then you may be liable because you invited that person to the home and didn't take precautions to make sure the guns were out of the way.
Yeah, in that case, there was a minor that was playing around with a gun that he found, and the gun went off.
Yeah.
Yeah, important distinction as well. A robbery in progress, or if you invite someone into the home. And of course, this time of year, folks like to get out and do some bicycling, Reed. And Rob said his wife was wanting to join the group of folks getting some exercise. So she was at a local bike store, and a bike actually fell off of the rack and went on top of her. She's not been to the doctor yet. Her neck's bruised and sore. So should they contact the store? Rob acknowledges that perhaps she should have said something at the time to the store owner, but she was just kind of embarrassed.
Sure. I would say immediately you need to contact the store and report an incident. The sooner the better. It obviously is better if it's that day. Now, if you haven't been to the doctor and you're not going to the doctor, there's probably your claim is very limited. And if they go to the doctor and she gets treated at the ER and the bills are very minor, and they don't find any kind of broken bones or torn ligaments or anything like that, and she doesn't want any physical therapy or chiropractic treatment, and it's just one visit to the ER, probably the best solution is going to see if the store has med pay. And med pay is payments regardless of fault. One of the hardest things in this type of case, a premise liability case, is showing how or why this bike fell. It could have been another customer, and if it was another customer that created the fall, then the store's not going to be responsible. Now, if the customer didn't and the store knew or should have known that the bike may fall on somebody, then the store may be liable. But then it goes back to damages. What are your damages? So in her situation, contact the store immediately, then get checked up, and then you can make a decision on whether it's a med pay or you're going to have to find some liability there.
And Vic, of course, you've shared in previous episodes of our program that you've helped out some patients in nursing homes and some folks, elderly, I guess, dealing with COVID and so forth. This one is from Mary, who has an elderly mom. She's over 90 years old. Mary's the caregiver. The doc prescribed an improper dosage of medication, which caused her grogginess, and she fell against a door frame, breaking one of her arms. She also has some severe bruises. And then Mary says, to add insult to injury, the same MD fired her as a patient. What can they do, Vic?
Yeah. Well, there will be a potential claim against the medical doctor for the prescription. The problem with pursuing a medical malpractice claim is that you have to have an independent physician who practices in the same field to review the circumstances of the prescription and be willing to testify that this was a breach of the standard of care. And then you would have to file a lawsuit. The problem with this kind of claim is it will cost you between $30,000 and $60,000 at a minimum to pursue a medical claim like that. She has a broken arm, which is serious. She had bruises. She had some grogginess. But unless you can show a very serious permanent injury, it's just really not going to be worth it. It's kind of like owning a gold mine. You might have gold in the mine, but if it costs you $4 to get every $2 out, it's not worth very much to you.
Yeah,
I love that analogy.
It's
Them
appropriate.
there gold in them hills.
That's right.
that's really
and
difficult too. Following on that same line, one thing that's difficult is to show that the negligence of the doctor actually caused the fall. So if this person was already treating for things, that she was already had grogginess or already had an unstable gait, you're going to have to show that this bad medicine or the improper medicine actually caused the fall. And that's very, very difficult. You're going to have an affidavit from an independent doctor.
Yep.
Okay, Reed, on the other side of the break, we'll look at the fact that Labor Day is coming and there's going to be some weekend parties. And Amy has a question about getting hurt at one of these parties, and we'll let the partners from the Hawk Law Group answer after we take a short time out. You're watching News 12 Law Call.
Welcome back to News 12 Law Call with award-winning broadcaster Neil Gordon. And from the Hawk Law Group, attorney Vic Hawk, with more than 30 years experience and millions of dollars awarded to his clients. Attorney Reed Sanders, born and raised in Thompson and known for his strong courtroom skills. With criminal law, former police officer, now lawyer Sean Merzlach. And with South Carolina injury law, trial attorney Chase Hawk. Plus guest attorneys from across the CSRA. Your rights, your calls, live. News 12 Law Call.
Welcome back to News 12 Law Call Zoom edition. I'm Neil Gordon. We reintroduced to the program the founder of the Hawk Law Group, Vic Hawk, and Reed Sanders. Reed, how many years have you been at it's more than a decade now, right?
Yeah, let's just leave it at that. Shave the beard to try to make myself feel younger. We'll just leave it at that.
12, 14, 16 years. You lose track after a while. I'm one of the partners of the Hawk Law Group, and really a kind of a specialist in slips, trips, and falls. And Reed, with the Labor Day holiday coming up, it's really a time for folks to barbecue and grill. Still might be nice weather for swimming, and accidents do occur. And Amy wants to know, what if she gets injured while at the home of one of her neighbors who invites her there for one of these upcoming parties?
Okay, and so this is a complicated issue, and we've dealt with it a good bit, Vic and I have. And this is something that it depends on what you are classified as. Are you an invitee or a licensee? If you're a licensee, that's essentially a friend coming to a party, and an invitee, you have to have mutual benefit. Like if you were going to a store and you're buying something, then the store benefits and you benefit. So if you have a party and you're charging to get into the party, then that can kind of gray the area. Well, if you're a licensee, a friend that's coming to a party, then the threshold for liability goes way up. You have to really show that they should have known, and it's willful and wanton conduct, essentially that there was a hazard of some sort that the homeowner, it was open and obvious and should have warned you about and didn't take any active steps and kind of led you in that direction. So the standard's a lot higher. Generally, in that situation, it's a lot more difficult to recover. So without any more facts in that, I would just say that it really depends on what type of, if invitee or licensee they were. And if they were a licensee, they're going to have to show that not only the homeowner knew that there was a hazard and didn't warn them of it, but that it was, almost that they allowed this person to get injured without any kind of help or knowledge at all. So that's a very, like I said, a difficult question to answer without more facts on that one.
Okay. Birthday parties are also big, of course, in our area. And we have one of these trampoline places in town that one of our viewers are speaking of. It's not this particular one, but Corey wants to know, Vic, how ironclad are the injury waivers they make you sign when you go to a kid's birthday party? He mentioned trampoline places, but I guess it really can be any type of activity at a birthday party if they ask you to sign a waiver.
Yes, there's a good deal of litigation over these waivers. The waiver has to be one that clearly indicates that this is a waiver of liability. The type has to be bold, it has to be prominent and unambiguous as to what's going on. Now, when the parents are signing for the children, that's another issue as well. Whether the parent can really waive the right of the child to a claim for personal injury. The parent could waive the parent's right to a claim for medical expenses by signing that waiver. But regardless, if you can show that the company engaged in willful and wanton conduct, let's just say, for example, you're talking about this trampoline. Say the trampoline was in disrepair, but they still allowed kids to get on it and use it. There were broken items on it, which caused it to be more dangerous than it was if it's used for its ordinary purpose. Then you would have a claim and the waiver wouldn't apply.
Vic, you ever take your grandkids to one of them trampoline places in or out of town?
I do, and I'm nervous as a cat on a hot tin roof because I can turn my back and one of those grandkids will disappear every time. I'm just and half the time when I find them again, they were right there in front of me. It's kind of like chasing a bunch of black labs in the dark.
Understood. And Reed, we actually have a trampoline at our home and we have one of those nets that go around. Sure. But I'm still really nervous, particularly since I read this email question from Angie. Her daughter broke her tooth playing on a neighbor's trampoline. She really wants to keep the peace with her neighbor, but she also wants to get the dental bills paid. What do you recommend here?
Well, I mean, you certainly could ask the neighbor, but more than likely there's not going to be any negligence involved that the parent or the owner of the home has. It's similar to what Vic was just saying. Now, if the trampoline was in disrepair and they knew it, then that's, can be willful and wanton conduct. But if this child is a licensee, now the standard is going to be higher because she's a minor for the parent, for the homeowner to make sure things are safe. But if a child is injured on a trampoline that's in good shape, and they're a licensee, meaning a friend coming over to hang out and jump on the trampoline, that's kind of play at your own risk, and without anything else, that you're not going to be able to recover against the opposite homeowner, and those bills you're going to have to take care of yourself.
Well, Vic, we've talked about.
Neil,
go ahead, Vic.
Let me interject something there as a follow-up to Reed. Always check to see if the homeowner had MedPay on their homeowner's liability insurance, because that's not unusual that there would be MedPay there and fault wouldn't be involved at all and can maybe get some help with the dental bill.
Right, especially with small damages like that.
Well, good point. We've dealt with businesses and play zones for the kids, and then being at your home. Now, a grayer area, I guess, which is related to a city playground, which there are many in the CSRA. And Vic, Sherry said that her daughter's leg was cut on a slide at one of these playgrounds. They're made out of plastic, of course. The plastic was cracked. So she needed 5 stitches. Is the city responsible for Sherry's daughter's injury since it simply didn't maintain the playground?
The city is probably liable for failure to maintain the city playground. But the problem that we have in our community is that a lot of the parks are owned by the counties. And the county employees have a huge cloak of sovereign immunity from being sued for failure to maintain playgrounds. So if it's within the city, the rules are different concerning potential liability. If it's in the county and it's county-owned facility, it's very difficult to pursue a claim. Now, there is a doctrine called the ministerial acts. If the county employee was on notice that the equipment was defective and the county policy directed the employee to repair it within 2 or 3 days, whatever it is, then you may be able to hold the county employee responsible, and the county insurance would cover any of the debt that he caused to this family.
Well, school is back in session, and we're going to take our last break, and we're going to deal with what happens when your kid's having lunch and slips in the cafeteria. Stick around. We'll be back in 2 or 3 minutes with the Zoom edition of News 12 Law Call. Hi there, and welcome back to News 12 Law Call Zoom edition. If you'd like to have a live chat with any of the attorneys of the Hawk Law Group, several ways to get in touch with them. You can go online to hawklawgroup.com. You can call all fours with a 706 area code, and they are seeing clients in a very sterile environment in the conference rooms of their 4 offices. So they're based in downtown Augusta with 3 other satellite locations. And we welcome back the head honchos, the 2 partners of the Hawk Law Group, the founder, Vic Hawk, and a gentleman celebrating his 40th birthday, Reed Sanders. Hello, gentlemen.
Hey, how's it going?
Good. We left off Reed sharing what we're going to talk about, which is accidents that can happen in the school cafeteria. Grant's son just got back to school, slipped on the wet floor there, ended up with a concussion, taken to the hospital. Just wants to know if this school has a fund through the insurance company, I guess, to pay for medical bills or what to do.
Right. And this is an ongoing theme. We've talked about it in the show, and Vic has talked about it a good bit about sovereign immunity and having immunities. And the school is certainly going to have that. And so you're going to have a higher level of negligence. And let's kind of take that out of play. One thing that you always have to remember in a premise liability case is assumption of the risk. And so all the things that we've talked about, and if a trampoline's not repaired, or a hole's in the yard, or the floor is wet, if you, as the person that is trying to make a suit, knows about it, and you still encounter it, then that you are assuming the risk of that hazard. And if you assume the risk of that hazard, then you can't recover. Now, there's different rules with minors and that kind of thing, but if the school is not going to necessarily be responsible if there's a wet spot on the floor, because a child could have spilled it and then not enough time to clean it up. There's just a million ways that they could avoid liability, and they have immunity. With all that being said, there still may be some type of med pay that this school covers that. So that's the first thing to look at. And if you don't have med pay, as Vic was talking earlier, there's probably not enough damages here unless there's future treatment to warrant trying to go after a defendant who has immunity.
All right. Last question for you, Vic. Sports injuries as it relates to the city or county. Brian broke his ankle tripping in a hole playing softball. Is the city he was in responsible because the fields were not safe?
Well, common sense is, as usual, is going to come into play. The person who was playing softball will certainly receive a barrage of questions about how many times they went out onto the field, if they had an opportunity to observe the field, if they had the opportunity to observe holes in the field or to disrepair the field, and still decided to play softball out there. That will be the main defense of the city for failing to maintain. If it was a county employee, they would have the additional cloak of sovereign immunity. It is a very, very difficult thing to overcome in Georgia. And in South Carolina, the rules are different. And I'll let Chase address those on a future law call. You can pursue the school for failure to maintain the premises, is what I understand it, the rule to be. But Chase can discuss that.
Sure, and then we don't have much time, so that's a long answer too for that South Carolina side.
Yeah.
What a great tease for a future broadcast.
Yeah, that's right.
You must watch every Sunday to find out the answer. You must. Thank you, gentlemen.
Thank y'all for watching.
Stay safe.